John, are you able to hear me in there?
Yes, I do.
Okay.
Yeah.
I think Ella said she can. Okay,
Yeah.
great.
I'll log in now.
Great, 10 o'clock. Good morning, everybody. I want to start off with not talking about the lease agreement, but I want to talk about filing an unlawful detainer action initially. So if you ever look at a 3-day notice of pay or quit, which I don't have on the screen, there is a warning indicating if there is a federally insured loan recorded against the property. So that could be Fannie Mae, Freddie Mac, through any traditional lender, for example, Bank of America, for example. Once again, I said VA, FHA. It's possible instead of a 3-day notice of pay or quit, that it may be required to serve a 30-day notice to pay or quit. And so the notice of pay or quit is not defective. Now, I went through this just last week with somebody. They have a VA loan against a rental property. Speaking to car attorneys, the law going back to COVID has never been amended. So it's possible that if you file a 3-day notice of pay or quit and there's a federally insured loan recorded against your property, that 3-day notice of pay or quit may be defective. So it's something, if you're going to be filing an unlawful detainer action, you may consider, and this is what we did in one case with Sarah's client, serving them with a 3-day notice to pay or quit, and then having that sent to the attorney that's going to be retained to file the unlawful detainer action and see exactly what their opinion is. But I just wanted to mention that to you. So CAR's recommendation is, and they're going to be very conservative in regards to any information that they give us, is to give a 30-day notice to pay or quit if there is a federally insured loan recorded against the property. It's crazy stuff. Yeah. Otherwise, it could be deemed defective, and who knows what a judge is going to do. So I just thought I'd mention that as we go along here. And I think the whole part of the purpose of today's discussion, I think we need to be more vigilant than ever in regards to selecting tenants, because it's getting more and more difficult to evict them, as a matter of fact. So let's just go through the lease agreement. Well, some of it's very simple, some isn't very simple. The date, that's just simply, once again, a reference date in regards to when it's being drafted. And if you issue any addendums to, for example, to the residential lease agreement, you would always reference that date, not the date that the contract is signed. So in this case, our tenant is Jesse Waters. You may have heard of him. And no, he's not a client, although I would like him to be a client of ours. And anyways, that said, section 1A, we would put the property address in. Section 1B, we're going to name the occupants of the property itself. Now, Jesse may be the only person that's on the lease, but we are also always going to want to name the occupants who will be residing in the property. It doesn't matter if they're 6 months old or not, but if we go through the lease agreement, if you're representing a landlord, if one of the occupants is 18 years of age or older, you should also be obtaining an application for that individual before allowing the landlord to come to a conclusion whether or not they're going to grant credit to somebody. Section 1C, the following personal property. So washer, dryer, refrigerator. Now under section 11, we'll also reference this because we don't want to maintain personal property. And now, unfortunately, at the beginning of the year, you're going to be required to provide a refrigerator in a rental property. Now, the law does not prescribe the size of the refrigerator, but you must provide something that provides refrigeration. So if you have if you're a college student, you might have a 2 cubic foot refrigerator. Maybe that's going to work, right? So that's what it leads to. It just says you must provide a refrigerator. So that's going to be a new requirement, as a matter of fact. And then section 2, the term begins on, in this case, it's going to be December 1st. Now, the interesting aspect of this paragraph talks about the fact that in the event the tenant does not deliver the funds when due, so let's assume we specify a time frame. Let's go down to, I'll come back, all right? If we look at section 5, we say that the rent from November 1st, it should be December 1st, we're past November 1st. If it's due November 1st or December 1st, if they don't pay it by that time, or if they don't provide you with the security deposit as defined in Section 5, the contract is voidable. So let's assume we sign a lease agreement, the tenants to be delivering the monies to me today for both security deposit and the move-in funds or the first month's rent. If they don't do that, you can serve them with a notice to perform, and 2 days thereafter, the landlord can void the contract. Now, why is that important from my perspective? If they're not delivering the funds when due, I think you're probably in a much better position voiding the agreement as opposed to going forward with somebody you're hoping, good morning, is going to pay you in the future. So that's something to keep in mind. The contract is voidable in the event the tenant does not deliver the funds due when they are due. So security deposit and the first month's rent, for example. So let's continue on. And then Section 3, rent. Well, tenant agrees to pay how much per month, right? We're going to say $4,000, but I skipped over this and I shouldn't have. Section 2, the term. It can be a month-to-month tenancy. In the event that it's a month-to-month tenancy, the tenant only need to give a 30-day notice to terminate a tenancy, and it can be given at any point in time. And prior to the tenant occupying the property for 1 year, a landlord also can give a 30-day notice to terminate a tenancy. But remember, termination of a tenancy is going to be predicated upon whether or not the landlord is entitled to the exemption from the Tenant Protection Act. So if you don't provide them with the RCJC indicating the landlord is exempt from the Tenant Protection Act, they may not be able to terminate a tenancy unless it's for cause, for example, non-payment. In this case, we're going to say it's a lease agreement, and it's going to begin or terminate on November 30th. So that makes sense, right? In this case, we're saying the lease agreement begins December 1st of this year, terminates November 30th, and we're going to say at 5 p.m. So what takes place if the landlord has actually obtained or provided an exemption from the Tenant Protection Act? Does the landlord have an obligation to renew the lease at lease termination? The answer is no. However, if for some reason the landlord did not provide the RCJC, the rent cap and just cause notice, and didn't check the box indicating they're exempt from the Tenant Protection Act, they very well may not be able to terminate that lease, or, which is a problem, as a matter of fact, if you think about that. So if there's only 15 reasons why a landlord who is not exempt from the Tenant Protection Act can terminate the lease. 3 of those could be, for example, I'm going to substantially renovate the property. That means you have to provide building permits, for example. I'm going to occupy the property, or a relative of mine is going to occupy the property. You're going to have to provide proof of that. And then the other 12 reasons are for cause. I'm not paying. But other than that, if the landlord is not exempt from the Tenant Protection Act or has not provided the exemption notice, they very well may not be able to terminate the tenancy. So that's a problem. And even if they're not exempt and they have one of the 3 reasons for non-causal reasons, they're going to have to provide 1 month's relocation assistance to that tenant in the event they terminate the tenancy. If I'm going to substantially renovate the property, I'm going to have to pay the 1 month's relocation assistance. If I'm just going to be changing the carpet, that is not a valid reason for terminating a tenancy. And then payments. Let's see, payment. Rent shall be paid by, it could be personal check, money order, cashier's check, or it could be wire or electronic funds. Now, I fully expect the lease agreement to change by the beginning of the year because the guidelines or laws have changed in terms of reimbursing funds received electronically. If you have multiple individuals on a lease agreement, right now the lease agreement specifies that if there's a return of the security deposit, it's to be made, the check is to be made payable to everybody that's on the lease, not the occupants, but the tenants themselves, as a matter of fact. So that can change, and the parties can agree to for example, a return of the deposit via electronic means, and you would actually have to have the tenants all agree in writing that I'm going to split it 1/3, 1/3, 1/3, for example, and I can deposit that electronically. So that's something else where I would expect to see by the end of the year, as a matter of fact, in a revised lease agreement. If not, sometime soon thereafter. Any questions about that? All right. And then let's see, section 3D3, if payment is returned for non-sufficient funds or because tenant stops payment, then after that, the housing provider may require the tenant to pay rent in cash for 3 months, and all future rent payments shall be paid by money order or cashier's check. So that's an option for the landlord, as a matter of fact. And then rent payments received by housing provider shall be applied to the earliest amounts due or past due. Now, security deposit, section 4A. How much can we charge for security deposit? I'm sorry, what? 1 month, right. And there's very few exemptions, as a matter of fact. If it's a small landlord, if it's no more than 2 properties, in which doesn't occupy or cannot house more than 4 people, that small landlord could charge up to 2 months security deposit, nothing more than that. If it's furnished, can you charge anything more than that? No, correct. That's correct, as a matter of fact. And even if the property owner is a corporation and I own 2 separate duplexes in which can house no more than 4 people, can I charge more than 1 month security deposit? The answer is no. Or if it's an LLC in which one member is a corporation, you can once again only charge 1 month security deposit. Service members, 1 month security deposit, nothing more than that, as a matter of fact. I'm sorry, what? As long as, if in our example, if the rent is $4,000 a month, we can't charge more than $4,000, and I don't care how you characterize it. You can call it pet deposit, but if the pet deposit is $500 and your security deposit is $4,000, you violated the law. Yeah. Another reason to be sure that your that tenants are screened appropriately, as a matter of fact. So now, everybody uses rent spree, and that's great. It simplifies things, but unfortunately, what rent spree does not do, it does not provide to the landlord the social security number for the tenant. So in the event the landlord wishes to provide a negative rating for someone who's violated the lease agreement, what are they going to do after the fact? Are they going to say, hey, would you please give me your social security number so I can report you to credit reporting agencies? Well, I think I know where that's going to go. So there's the thought that you may, in addition to rent spree, you may have the traditional rent screening application completed by the tenant, so you have the tenant's social security number.
I have actually 2 lease, and both of them refused the rent spree. They said they prefer to go with car. Like they said,
oh, the tenants preferred to?
No, the listing.
The listing agent.
Yes.
That's probably why, because they can't get the social security number through rent spree. So that's a thought. Just want to keep that, make you aware of that.
Excuse me.
Yes.
I actually closed a lease this morning, and so I was working for the tenant, not the owner, and they were charged a full month's rent plus a $500 pet deposit. So that
for a security deposit?
Yeah. So should I do anything about it, or is it just not my problem because it was the listing agent that did it?
Were they exempt?
Well, I would say it's our problem.
Yeah.
We should have notified the listing agent that they're violating the law, assuming that if it's a small landlord, so if they own 2 single-family homes, it's not in violation.
Okay, I think they only have 1.
All right, so if they only have 1, they're entitled to charge up to 2 months rent for a security deposit, as a matter of fact.
Thank you.
So it's a good question. I don't know if people necessarily recognize what could or couldn't be a violation, but that's a very good question. And then section 4B, security deposit, is in addition to any advance payment of first month's rent. Security deposit law does not prohibit the payment of advance rent of not less than 6 months rent if the term of the lease is 6 months or longer. Would anybody like to define that for me, exactly what I just read? If not, I will do that for you. So you can charge security deposit plus 1 month's advance rent, nothing more than that. However, if the lease term is 6 months or longer, you can charge 6 months advance rent or more. So you can require them to repay the entire year, but you cannot charge 2, 3, 4, 5 months advance rent. You can't say, well, first and last, because now you've violated the advance rent and or security deposit. So you cannot do that. You can only charge more advance rent if the lease term is for 6 months or later or more, and you charge 6 months or more for the rent.
What about on short-term rentals?
Short-term rentals don't apply. If you think about it,
Yeah.
right? Because it's not 6 months or more. Any questions about that? Okay. And then section 4C, I think typically, we'd suggest that security deposit will be transferred to and held by the owner of the premises. I think it's better for us, as a matter of fact. We don't really care to hold security deposits if we're not the property manager, as a matter of fact. And then section D, which is section 4D, you can see in bold print, it says security deposit shall not be used by tenant in lieu of payment of last month's rent. I hear this constantly in regards to tenants applying or claiming, Joe, just deduct it from my security deposit. But let's assume that you have repairs that have been caused by the tenant. You want to charge them back. You can do one of two things. You can just bill them for it, or you can apply the security deposit against those repairs. And if you give them notice, they have 5 days to replenish that security deposit. Likewise, if they apply the security deposit to last month's rent, they're violating the lease agreement. I don't know if there are really any great alternatives other than to say you must replenish that, and then good luck collecting, because they're probably going to be leaving the property anyways. So there's the law itself, unfortunately, and then how do we actually manage this in the best interest of our clients? And then section E, security deposit will not be returned until all tenants have vacated the premises and all keys returned. So any security deposit returned by check shall be made out to all tenants named on the agreement. So once again, if there's multiple people named as tenants and the landlord's going to be reimbursing a security deposit, make sure every single name is on that check. That is the safest approach for the landlord. Don't send it to just one individual, unless for some reason they negotiate in writing that everybody has agreed to do that. Likewise, if you ever have an amendment to a lease agreement where you're adding or removing a tenant, and there's a security deposit associated with the transaction, most likely there is, then I think you need to, if I'm removing a tenant, then I'm not going to return the security deposit, but we should amend the lease to state that the remaining tenant will be the beneficiary of that security deposit upon lease termination. So we need to have the tenant that's no longer in the lease agreeing to relinquish any rights they have to that security deposit. And then let's see what else. Under section 5, move-in costs. Nothing uncommon here. We should specify the date in which the security deposit is due and or the first month's rent. So in the event the tenancy begins mid-month and we collect 30 days advance rent, how do we manage that? Well, the lease agreement specifies that we'll collect, for example, $4,000 if it begins November 15th and it's through December 14th, we'll collect the $4,000 in advance. And then for the remainder of December, the tenant's going to be obligated to pay a pro rata portion of the rent for the month of December. And it's based upon a 30-day proration. So if, let's say, for example, the rent is paid through November 15th, December 16th, and let's simplify it, 15th, there's 16 days remaining in December. So if the rent is $100 a day on a per diem basis, we would pay $100 times 16 days. So that's how the lease agreement is structured. You can actually structure it such that they only pay the pro rata portion for the very first month that they're occupying the property. But what you don't want to do is if the lease agreement begins November 15th, we don't want to collect the remaining 15 days for November plus December's rent, because now we've violated the law. You can only collect 1 month's advance rent or 6 months or more if the lease agreement is 6 months or greater.
Rich, I thought that you had to do the proration based on 30 days,
I think I said that.
but you're saying 16 days if they paid from the 1st to the 15th.
No, I'm saying the proration is based upon 30 days.
Right.
Right. So if I simplify and say the rent's $3,000 a month, it's $100 a day.
Yeah.
Right. Well, actually,
Okay,
because
got
it's
it,
saying
got it.
based on a 30-day proration.
Okay. And then is it okay to put the December rent in there? Just to let the tenants know, hey, this is what you're going to be responsible for, just for half the month of December?
No, I wouldn't do that because it's telling them that they have to deposit that money up front.
Where it says other, though?
Correct.
And then put a date on it. Of
So
when
if
it's
we're
due.
beginning mid-November,
Yeah.
we don't want to collect more than 1 month's advance rent.
Right.
But if you put December now for the remainder of December, now you're telling them they need to pay that. I would not do that. I would just send an email or a message to say, don't forget, as of December 15th or 16th, you're going to owe this amount of money and it's due by this date.
Okay.
I would not include that in the lease agreement. It may imply, possibly, that you're collecting advance rent, but I understand what you're saying. Under the due date, I guess that probably would be acceptable.
Just to clarify for
Yeah.
them.
Yeah, that's actually a very good idea, Carlos. So I'm going to take back my comments. Okay. And then let's see. Get some notes here. Oh, this is always something. Under section 6A, when is rent due? Well, the rent is due based upon the traditional lease agreement on the 1st of the month. You have no obligation to give a tenant a 5-day grace period. Personally, I put 1 day in there, right? 6A instead of 5 calendar days. I would give them just 1 day grace period. If it's due on the 1st and they don't pay it by the 2nd, they're already late if they don't pay it by the 1st of the month. So let's not give them any leniency in regards to taking advantage of 5 more days, possibly. No matter what, with the grace period, they're still late if they don't pay it by the 1st of the month. So preferably for me, or put 0. I think we need to be aggressive with tenants, as a matter of fact. And then late fees, I have 6% in there. And even though there's no statute specifying what the maximum late fee can be for a residential property, the court's deemed to be acceptable a 6% late fee. And that's kind of based upon late fees associated with lates in the event you're paying your mortgage late. You put more than that in there, it may not be defensible. And then let's see, section 7, parking. And then my suggestion is parking is permitted as follows in the garage and or assigned parking spaces and nothing more than that. And you can check the box that it is included in the rent. If you don't want parking on the premises, you can check that box also. Section 8, the easiest thing to do in regards to storage is to check section B. Except for tenants' personal property contained entirely within the premises, storage is not permitted on the premises. Now, what if somebody, it's a condominium project, or actually could be a single family home, and let's assume it's a condo, and they have an assigned parking spot, and they have a car that is not currently registered. Are they in violation of the lease agreement? Yes, they are. They can't just store crap on a common area. So it's a violation. Not only that, but the HOA is going to contact the homeowner and say, hey, you're in violation of the rules and regulations. So anyone that has a vehicle they're storing, it must be currently registered. And then utilities, well, it says tenant agrees to pay for all utilities and services and the following charges. Now, it's up to the homeowner if you want to have the tenant pay the HOA dues, for example. So be careful. I think when you're looking at the MLS from time to time, you may see a rental rate but then also the listing may indicate that the tenant also pays for the HOA dues, and that can be very expensive. So it could be a real surprise. And then under section 9A, water submeters. If it's a multi-unit home, a fourplex, sometimes there's only one water meter, and the landlord could, if they want, prorate that among all the tenants. No obligation to do that if that's the case. Check the box. Gas meter, the premises does not have a separate gas meter. I don't know if that's true, but I think I have a fourplex that doesn't have a separate gas meter or water meter. So there you go. It exists. Then electric meter, the premises does not have a separate electrical meter. So it's going to be applicable to multifamily housing, nothing more than that. And then this is something that's always a question, I would say, condition of premises. Tenant has examined the premises, and if any, all furniture, furnishings, appliances, landscaping, and fixtures, including smoke alarms and carbon monoxide detectors. So there is a form. Let me find that. And it's changed from the move-in, move-out form, and probably everyone's aware of that, but I just want to bring it up.
You have it on top, actually.
How do I? Okay.
You pass it up. There it is.
There it is. The move-in inspection form. This is what it's referencing. And what's different about the move-in, move-out form versus the MII is the fact that if we look in this box in bold print, unless otherwise checked, all items are in satisfactory condition. So the default is, so let's assume the tenant moves in, we give them this form, the landlord signs the form, and there's nothing filled out on the form, the landlord stating everything is in working condition and it's in good condition. So it's up to the tenant then to contest that. So the default responses in this form, everything is perfect. So it kind of simplifies it. And in the event, let's go back to the original form. I'm going to find it. So we have options. 10A, tenant's acknowledgement of the condition of these items is contained in the attached statement of condition. You can attach the MII to the lease agreement. You can do that. That's an option. You can check all of the boxes if you want. Or you can say section B, that the housing provider will deliver to the tenant a statement of condition within 3 days after execution of this agreement, prior to the commencement date, or within 3 days after the commencement date. What do you do, Mike?
I think I use C.
You do. Okay, so you don't. So C would be another selection, but I think what we want to do when we complete the lease agreement, we want to specify to the tenant, we're going to give you the form up front, telling you there's no deficiencies. We're going to give it to you upon the time you move in or lease commencement, or you're going to have 3 days after lease commencement to respond to the form MII, which says it's blank, there's nothing wrong. If they don't respond, then they're, in a sense, agreeing to the fact that the landlord's statement of no deficiencies is correct. If you were to say section C, and there's what I would do, I would probably choose 10A and 10B, and I would deliver the MII prior to the commencement or within 3 days of execution of the agreement. That would be one of my choices. So I give it to them. They have it. 3 days passes. You had this look on your face.
Yeah, I've seen instances where the landlord fills this out and they mark what's deficient, and then they give it to the tenant and have them sign it.
That's what they should be doing.
Yeah.
But they choose the option that they think everything is perfect.
Everyone else just sends it blank. Say, here you go.
Well, yeah.
Yeah.
I think that's what you should expect when you're
Right,
representing
right.
a tenant or a landlord. They're going to just sign it. And the inference is, or the representation is, there are no deficiencies in the property. So it's then up to the tenant to dispute that. And then remember now, as of July 1st, what must you do as a landlord? I'm gonna give you a hint. What? Pictures before move-in. That's, yeah, before move-in, and then prior to lease termination or prior to correcting any deficiencies, pictures again. And then-
video.
Pardon me?
You can use video as well, right?
You can use what else?
Video.
Yeah, I don't see why not, right? So pictures before move-in, pictures before any repairs take place, and then pictures after repairs have taken place. Yeah. And if you don't do that, and the tenant contests any money being withheld from security deposit, well, you very well may lose. So that was as of July 1st. Remember, April 1st, you didn't have to have pictures before move-in. It was just prior to repairs and subsequent to any repairs that the landlord may have completed. Leases are much more complicated than the purchase and sale transaction. It's crazy. So we talked about the condition of premises. And then section 11, it talks about maintenance. The tenant has an obligation to notify the landlord of anything that's in disrepair, or what if there's water damage, things like that. They have an obligation to notify the landlord within a reasonably expedient period of time. Otherwise, the tenant theoretically is going to be responsible for those repairs. Then realistically, the landlord should have all working light bulbs in the premises before the tenant occupies the property. And then upon the tenant returning the premises to the landlord, they should replace all the light bulbs. So that's something that you very well can charge them back for. And then section 11B, who's going to take care of the garden and landscaping? Well, let's say tenants. And then also landscaping, trees and shrubs, except, well, let's make sure they take care of everything.
I think so. I think it's so dangerous to be a tenant to maintain the garden and landscaping, because if you are not a plant person, let the owner to deal with that.
Yeah, well, if they don't, the owner has the opportunity to charge them back and during the tenancy if they don't maintain the property. But I don't know how many landlords are going out to their rental properties to see whether or not a property is maintained appropriately. So that's an issue. I don't disagree. Outside of that, or the landlord separately, maybe if you're advertising a property, MLS says I'm going to charge you $200 or $300 a month to maintain the landscaping. So those are all options for you. Periodic pest control. If you are doing that, then if you have periodic pest control prior to the tenancy occurring, you notify them of that. Then section H, the following items of personal property are included in the premises without warranty. So we said on page 1, we're going to include the washer, dryer, and refrigerator. If we don't want to warrant it, then be sure you include it under section 11H. And then section 11J, tenant shall not use the premises to plant, grow, cultivate, or sell marijuana. Seems logical, huh?
So even though the landlord has to provide that, they don't have to maintain it?
I would say that it's personal property, right? In terms of maintaining the refrigerator, I don't know the exact answer to that. Washer and dryer, if we put a TV in there, there's no obligation to do that. But possibly now the refrigerator, just like the stove, may have to be maintained by the landlord. And then 12 neighborhood conditions show noise. Who knows, you're in a commercial area, or you look at Megan's website and there are predators lurking in the area. So those are all things that are very important, as a matter of fact, but that's up to them to research that. And then if they have animals, be sure whether it's a pet or animal, then you want to attach the animal terms and conditions addendum. And then smoking is prohibited unless you specify what kind of smoking is permitted on the premises. And it talks about the fact that the landlord may be entitled to recovery for replacing carpets, paint, so on and so forth, regardless of the age and or condition of the carpet and or paint at the time the tenant occupies a property. Rules and regulations, I think that's self-explanatory. So in regards to the rules and regulations, we're not talking about the rules and regulations of the if there's an HOA, for example. It is talking about the landlord's rules and regulations. So you may want to say, I don't want any nail holes. I don't want anything like that taking place on a property. So you should be giving them in advance of the occupancy taking place. And then if it is in a condominium or planned unit developments are very common, as a matter of fact, just because it's not a condominium. Probably in Irvine, I would say for the most part, most tend to be in a planned unit development. Well, your farm area, Mike, is that a PUD?
Yeah.
Yeah. So there are rules and regulations associated with that you should be providing the tenant. And then section 18, well, first of all, section 17, alterations or repairs. The tenant, and it specifies they shouldn't be putting screws in, changing the locks, things like that, and you can charge them back for that. But it says large nails. It doesn't say anything about small nails. If you don't want any nail holes in any way whatsoever, give them your own rules and regulations. And then we're going to specify in section 18 the number of keys, so on and so forth, that's provided to them. And they should be returning all of those and any openers. In addition to that, if it's in a common area in which there are public or pools, things like that, they have the obligation to pay for the deposit to obtain the keys to those common area facilities. Landlord does not have the option or obligation to do that. And then entry, well, there could be reasons why a landlord may need to enter the premises. And this specifies the reasons for that. And then section 19C, tenant authorizes the use of a key safe lockbox to allow entry into the premises and agrees to sign a key safe lockbox addendum. Now, sometimes tenants object to that, but we certainly would ask them to do that. Photographs and internet advertising, it's possible that, well, there's nothing you can do about it. Once a picture is posted on the internet, it's virtually impossible to remove that. And then if somebody else comes into the premises and they're a prospective tenant, they take pictures, there's almost virtually nothing you can do about that. And it's talking about that in that paragraph. Assignment and subletting, without consent from the landlord, they cannot assign their interest or sublet the property to anybody. And it's up to the landlord to make the decision if they do permit that. And even in the event the landlord agrees to sublet or an assignment of the existing lease agreement, the tenant is still responsible for the balance of the terms of the lease. And it specifies that in here. And then section 23, joint and individual obligations. So if I have 4 students on a lease agreement, they are all jointly and several. If they're in default, the landlord has the option of pursuing all of them or one of them. They don't have to go after everybody. As a matter of fact, if there's a guarantor, well, I'll get to that as a matter of fact. And then section 25C, right to a pre-move out inspection. A tenant is entitled to a pre-move out inspection of property no sooner than 2 weeks prior to lease termination. And that gives them the opportunity to correct any deficiencies in the property. However, what if the tenant is in breach of the lease agreement, non-payment? Are they entitled to the same right in regards to a pre-move out inspection? No, they're not. So for any reason they're in breach of the lease agreement, you have no obligation as a landlord to give them that 2-week opportunity to correct any deficiencies. And that's the same thing with early termination. So section 26, breach of contract, early termination. This tells the tenant that the landlord has the opportunity to recover from the tenant lost commissions, the cost to repaint the property. In addition to that, remember, they need to return the property in the condition in which they found it. And that's why that move-in information form, the MII, is very critical. So the landlord can charge them back for everything, commissions, lost rents. So how do we, that's an issue. Let's assume the tenant breaches the lease agreement, they're moving out early. What can the landlord charge them for? Well, any cost to prep the property, to release the property. The landlord can also estimate the duration of time that the property is going to be vacant and deduct from the tenant's deposit that amount of money. So they can estimate that. And when must you give them notification that of any deductions from the security deposit? Within 21 days from the date that the tenant vacates the property and turns over all keys. So once they vacate, turn over all opening devices, that's the time frame in which the landlord must respond in writing to give tenant notification of any deductions made from the security deposit. And if there's still something remaining, you should be writing a check for the balance of that money. Otherwise, you could be subject to returning the entire security deposit and a penalty of 2 times the security deposit if you don't apply or adhere to that time frame. Let's see, temporary relocation. Let's assume you have to have the tenant move out because there's water damage in the property. Well, the only obligation you have as a landlord is to credit them a per diem basis of per day of 1/30th of the daily rent. So they may want to stay at the Ritz-Carlton, but the daily per diem is only $100 a day. That is the obligation the landlord has. If it's going to be more than 30 days, which the tenant can occupy the property, either party can terminate the lease agreement. And insurance, what is very important, I would always make sure that we checked section 29C. We want the tenant to carry liability insurance. So
I have a question about that. So I have a tenant that there's a leak in the property. It looks like there's mold. The tenant's canceling the lease, and both the landlord and tenant agreed to cancel the lease. Can the landlord use the tenant's insurance to pay for like repairs or mold remediation?
I think if there's any suggestion that maybe the tenant was the cause of it, why wouldn't we try to use the tenant's insurance as a means to remediate or address those costs?
So they would have to prove that the tenant caused that.
I would think so. Probably if it's not at the tenant's, if the tenant had nothing to do with it, I think the insurer is probably then going to deny the claim. That's my thinking.
And then also, did the tenant notify the landlord about it to fix it?
Yeah, it sounds like the tenant did.
Yeah,
They did. But there's mold.
Now, what's interesting, the tenant did an inspection because they're concerned because they have 4 kids. That mold report came back positive for toxic mold. The landlord did an inspection, but has not shown it to the tenant yet. So
I don't know if the landlord has an obligation to show that. I would only show it to them if it's beneficial to me at this point in time.
So basically, the insurance is only for the tenant's items and to protect the landlord of liability.
Yes, correct. So I would say that probably in that case in which, if it's not a slab leak, then no one's insurance is typically going to recover or cover most of those costs anyways.
Yeah.
If it's slow degradation of any of the systems, homeowner's insurance typically does not cover it. But if it's a major water spout that's happening in the house, then the insurance is going to cover it. So I would attempt to use the tenant's insurance policy initially, as opposed to using my own insurance policy.
Wow.
See what they do. In the worst cases, they deny it, but the claim should be made. Carmenza, you got a question?
Yeah, I was wondering about the damage to the premises. For example, what happened with the people in the fires in LA or the mudslides, and they're in the middle of the tenancy. So it says that they have a prorate 30 days to they return the money, or they pay the hotel for the whole rest until the termination, how it works.
Well, if they can't return the premises within 30 days in a habitable state, either party can terminate the lease agreement. But let's assume that the event occurred 2 weeks ago. The landlord has an obligation to reimburse the tenant going back to 2 weeks ago when that event took place that destroyed the property. So that is their only obligation, nothing more than that.
So that's paid by the insurance of the owner?
Well, I would assume, well, remember, paid, usually in an insurance policy, there's a clause for lost rents. So very well, the landlord could collect for not only that period of time beginning 2 weeks ago, but through the time that the property is habitable. And I have to wonder, is an insurance company at the expiration of that policy going to renew and continue to pay the lost rent provision? I don't know what the answer to that is, but yeah, that's because it's going to take years for those homes to be reconstructed, if ever. So yeah, insurance and Steve Dowdy had brought to my attention one of his clients. They had when they didn't want to choose a tenant that had a pet, they then said, we want $3 million in liability insurance. It's discriminatory. So all they did was try to cause the tenants to say, I don't want to move forward with this, right? Tenants submit an application, in a sense, they're approved. The landlord then finds something about the tenant they don't like, even though they approved them, but you need to provide me with $3 million of insurance coverage. So I wouldn't do that. If you apply that equally to every single tenant, then that's probably acceptable.
That's what you got.
That's what yeah, just amazing to me. But I guess it's worked, huh? Yeah. Has anyone ever obtained an insurance policy with $3 million of liability coverage?
I only held it a couple times. He didn't want
Okay, all right.
You know, John.
I do. Yeah. So that's just, I think that's a clear example of discriminatory behavior on behalf of a landlord. And then section 33, tenant estoppel certificates. So remember, a landlord may own a property, they want to refinance the property. The tenant, because it's contractually included in the lease agreement, has an obligation to provide or sign an estoppel certificate, meaning they're going to validate the terms of the lease agreement, the deposit, rents, if there's any deficiencies, so on and so forth. In the event the tenant doesn't do so, the lease in this case says that if they don't respond, that the tenant is acquiescing and suggesting that the terms of the estoppel notice submitted are accurate. So a lender theoretically could rely on that when refinancing the property. And then section 34, if you have a tenant that's in a property and it's coming up for renewal, landlord has the opportunity to requalify them. You may not want to do that. It might make them angry, but you can actually render, they're granting permission to obtain their credit once again. And if it doesn't meet the landlord's criteria, then obviously there's no obligation to renew the lease. And then section 35, mediation. If there's a dispute between a landlord and a tenant, excluding something, for example, that could be just or contested through small claims, mediation is a requirement. Otherwise, if you don't mediate, this is no different than the purchase contract. The prevailing party is not entitled to recover attorney's fees and costs. And that's another issue, section 36. So here's always the issue. Attorney's fees. The default response in the lease agreement is that no party, even a prevailing, can collect more than $1,000. That's the default language. If you want to be able to recover more than that, you need to change this section, as a matter of fact. So that's a thought when considering litigation. Yes, I might sue you and try to recover this money. However, it's going to cost me a lot of money to sue you And likewise, from the tenant's perspective, if they're going to sue the landlord, it's limiting recovery of attorneys and fees and costs to $1,000. And it's rare, I would say, I haven't seen anybody ever modify this paragraph.
What do you recommend?
What do I recommend? I think the best thing, if there's a dispute, I would just leave it at $1,000. I would just accept the default and not raise attention to it. And remember, if you're evicting somebody, it's rare that you're ever going to recover any of the lost rents, so on and so forth. You're going to have to find these people after they move out. You typically don't have a way to recover from them, which is difficult. So just because you evict them doesn't mean that you have a money judgment for unpaid rents or any other damage to the property. That's a secondary action and associated with an unlawful detainer action. So from my perspective, getting somebody out of the property is probably the most beneficial thing you could do and move on. Everybody gets angry, and I understand that. We want to recover our money, but you may never do that possibly. And then section 38, disclosures. We should always check the boxes for mold and dampness. Residential environment hazards booklet. Bed box is already included. Why do we check these boxes? Because all it does is prevent the landlord or insulate the landlord from any litigation. So especially if we talk about section 38D, residential environment hazards booklet, we give them the booklet, anything that's mentioned in there, theoretically, the landlord is insulated from litigation associated with the tenant, claiming that, well, maybe it was built on a nuclear site, for example, right? And then section 39, Service Members Civil Relief Act, it's talking about sections 3951 and 3955 of the act. Well, if a service member is called to duty and duty is going to be more than 90 days, the service member can terminate the lease agreement. There's no recourse that a landlord can take against them, as a matter of fact. So that could be a big issue, as a matter of fact. So, and that's protection from eviction also. And you have to evict somebody judicially if they're a service member. And it's unlikely that a court is ever going to grant that, I would assume. And then, as a matter of fact, for a service member, this protection holds true for them, whether it's a residential lease or a lease of a vehicle. So if they're called to duty for something for more than 90 days, they can terminate a vehicle lease without any repercussions. Very interesting, huh? It might help a service member if they have a lease on a car. Let's see, what else do we have?
The screen's
Oh,
not
shit.
showing.
Okay, great. I'm going to skip over confirmation of agency relationship. We'll talk about that later because it's getting close to 11 o'clock. And then section 42, broker compensation. Why is this important? So let's assume you're the listing agents. You, based upon the listing agreement, you can specify in the listing contract, and the landlord's agreeing to this in the residential lease listing contract, that any monies that the tenant is paying, you can collect your commissions directly from the tenant upon lease commencement. So we say the tenant's got to pay $8,000, $4,000 for prepaid rent and security deposit of $4,000. Well, sometimes landlords don't want to pay us, so we can actually, within the lease, confirm the fact that the tenant is to be paying Coldwell Banker Platinum Properties $2,000 for our commissions. So that's what this can be used for, as a matter of fact. And then I don't know what's taking place out there, but I'm getting the impression that when somebody's representing a tenant, for the most part, when the agent representing the tenant is asking the landlord to pay the leasing agent's commission, most landlords tend to be declining that opportunity. Is anybody here getting a landlord to pay for your commissions if you're representing a tenant?
Yes.
You have?
Yeah, today.
Oh, you did? All right, so the landlord paid for that. Good for you. You're the exception, Jonathan.
Of course I am.
Yeah. And then one other aspect. State brokers. went too far. Guarantee. So remember earlier we talked about the fact that the default language in the contract is such that if there's a dispute, the prevailing party can recover no more than $1,000 for attorney's fees and costs. However, if there's a guarantor, there is no limit in regards to what the prevailing party may recover from the guarantor. So in the event the tenant doesn't pay and you have a guarantor signing this contract, you as the landlord can pursue the guarantor. You have no obligation to pursue the tenant for any deficiencies. You can pursue the guarantor. In addition to that, there's no limitation. So you can collect from the guarantor all the costs theoretically that you've incurred. Of course, the judge is going to make the decision what you would be awarded. So there's some benefits of having a guarantor. And I remember if you accept a guarantor when awarding a lease agreement, if you choose to not award or allow a subsequent tenant to have a guarantor, it's probably discriminatory. So you need to be consistent in regards to any lease agreements that are awarded. So if you allow a guarantor one time, next year when it's gone on the market and somebody you don't want them in, even if they have a guarantor that meets the criteria, that could be deemed discriminatory because you're not applying the same standards to those individuals that are attempting to lease the property. So that's it for me today. There's one other form, offer of tenant positive rental payment reporting. So this is all part of the lease agreement packet, unfortunately. So bed bug disclosure, tenant flood hazard disclosure, rent cap and just cause addendum. Remember, for the most part, we want to be able to check this notice of exemption. So let's assume that we don't check that and the landlord theoretically is exempt. Well, there's nothing we can do. Well, there's a few things we can do during a lease. We can actually send this form to the tenant. They have no obligation to sign it once we put them on notice that I'm exempt. However, after the end of the lease agreement itself, the expiration, you may not be able to terminate the lease agreement, and you could allow it to become a month-to-month tenancy, and thereafter you could then send the RCJC attached to a notice of change in terms of tenancy, and 30 days thereafter this could become effective, and then you may very well have the right to terminate the lease agreement. Of course, you're going to have to give a 60-day notice in my example. So it's very important that the rent cap and just cause form is completed appropriately. And then another form, offer of tenant positive rental payment reporting. I would say for the most part, most landlords are exempt. Be sure to check the box, notice of exemption. Those landlords to which the exemption is not available, if the premises is located in a rental property that contains 16 or more residential units, they have to give the tenant the option for positive rental payment reporting. And then also, if the premises is located in a rental property that contains 15 or fewer residential units, and both of the following apply, the housing provider owns more than one residential property, that's not hard to meet, regardless of the number of units, and the housing provider is a real estate investment trust, a corporation, or a limited liability company in which at least one member is a corporation. So if I'm a landlord and I have one property and it is held by an LLC and one of the members is a corporation, the exemption is not available to me. And I have to give the tenant the opportunity for positive rental reporting. I think that's probably not the case for most landlords, as a matter of fact. However, but if it's a corporation that owns a property, even if there's just one rental property, the notice of exemption is not available to that landlord. Okay, any other questions? Any questions at all?
One question.
Oh, hi, Shweta. Did you put your question? Can you put your credit?
That one I have already assigned it to Steve.
Oh, you did? That was nice of you.
But anyways, my question was, you said like once you have a guarantor first year, the second year you decide you don't want a guarantor, and that's considered discrimination?
I would say, what would be the reason to decline?
I had a bad experience with the last guarantor, and so this year when I'm putting it out back for rent, I don't want the guarantor.
I think that there could be the inference of discrimination. That's the point, because my criteria now changed from 1 year to the next. What about any other criteria? Did you just decide? Did the landlord decide that any other criteria has changed?
No, like pets, like now, the first year he's had pets, and the second, then now the tenant has moved out, he's putting it back on the market, he's, I don't want any pets. So,
I think pets and accepting a guarantor are two different things. So is there risk? The only risk that I see is in the event the tenant that you declined credit, even though they had a guarantor that probably met the criteria, their prior guarantor, if they claim discrimination and they find out that you accepted a guarantor the prior year, why aren't you accepting the guarantor now?
because it was a pain in the ass, chasing the other guy.
Why was it a pain in the ass?
Well, why do I need to explain so much to a person that I don't even know? You know, how does he know?
Well, I think that's a question. That's what it comes down to. Or did you just not like the tenant?
No, because it was just like, oh, the guarantor was out of state, or like,
I think that's the reason to never accept a guarantor, because you don't know if they're in state, out of state, and I think you're better off just being consistent, typically, in regards to how you approach the lease agreement. So I would say the same thing, maybe, as long as your criteria is such that I'm not going to accept an out-of-state guarantor, and that's the way I've always evaluated my tenants. I think that's probably reasonable.
but then I'm stuck with in-state gap.
Yeah, or you just decide I am never going to. Why would you no longer accept a guarantor? Because the tenant defaulted, and then I had to pursue the guarantor, and I couldn't find them.
Yeah.
So maybe that's a valid reason. But if simply the occupancy expired, tenant move out, you never had to pursue the guarantor, but now you just make a decision. I don't want to accept any more guarantors. I don't know if that is a basis to decline a guarantor. I think it's just a matter of being careful.
Pets are okay.
Pets are okay. I don't see anything wrong with that. You have no obligation to accept a pet.
Yeah, like if 1 year I accept it, next year I don't accept, it's fine.
Well, no, I'm going to rescind exactly what I said. So I accepted a pet last year. I declined someone with a pet this year, and it's the same size dog. But then next year, I accepted a pet, the same size dog. So now you've set a precedence from my perspective. What is it?
What about the emotional support animal thing though?
You have no choice.
Yeah, that's what I thought. So if they have that, then you can't.
But that's not a pet. That's an animal.
That's an animal.
That's a difference. I know
there's
you're
no more
just
pets.
looking at it logically.
There are no pets.
Like, oh, there was a damage, or there was an odor that was left in the house, and
Uh-huh. Yeah.
that's the reason why.
Yeah, I think that's a valid reason. I'm never going to do it again. I was burned once before, so I'm never going to allow that to happen again.
So you can do that, but except for the character.
Yeah, yeah, just something to be aware of. If you accept one, you should probably give that consideration for every time that you lease the property again. Okay, yeah, I think those are good questions. All right. Thank you for coming. Oh, by the way, don't forget, please respond to the invitation for the Christmas party. All right, so that's December 4th at 5 o'clock.
I like that time.
Yeah, it'll be fun this year. We're gonna have dancing, DJ, dance floor. I don't know. I'm wondering, Mike's gonna wear this year.
Yeah. I was telling Carlos, maybe there should be a code like everybody come in pajamas.
No.
I told her Rich would never go for that.
Target is gonna be sold out, right? And if you're going to bring a guest, you're welcome to bring a guest. Just please let us know. So that would be very helpful. I thought there's one other thing we needed. Oh, that's the other thing. So next week, there's going to be an inconvenience in the office, and that's not because of me, but excluding the offices, this entire area, including the conference room, the small conference room, it's going to be repainted. So Monday, I think it's going to take 3 days when you come in, Monday, Tuesday, or Wednesday. Just please be prepared. There's going to be painters on the premises. So that was the other thing I wanted to mention, right? Just
And no office meeting next.
no
next
office
week.
meeting next Tuesday.
And now we're going to
Exactly.
be closed on Thursday.
Exactly. Yeah, for Thanksgiving. Exactly. All right. Well, thank you, everybody. Thanks for coming.
Thank you.